As you know, in this area, the key on the California bar is the difference between the model rules and the California rules. This topic can come up on the essay section, or it can certainly come up on the performance section of the bar. You have a great outline with BarWinners here. In addition to the approach that you should be looking at, there's a fantastic chart that gives you those differences. That's what the California bar is looking for. They're looking for that you know the differences in California versus the other states. So that's really excellent tool for you. In addition, we're going to be looking at both the Jones and the Betty essays tonight, and you can log on to BarWinners to get that information, but we'll be going through those in addition. All right, so let's talk about professional responsibility. Again, I said it can come up on either the performance or it can come up on the essay section of the bar. Why? It's tested every single bar and sometimes multiple times. There is actually a letter to the law school deans from the Conference of Bar Examiners saying we're going to test it. The reason we're going to test it is because they want you to be ethical in the state of California. They believe that if you're tested and you pass the California bar on this topic, that you will be. So that's kind of their enforcement mechanism. Okay? You're going to find that California will differ from the model rules in certain areas. Those areas are very testable. Okay? Why? You're sitting for the California bar. It's a California-specific topic. All right? So I will highlight those as we go through. But again, the BarWinners chart does an excellent job. And actually, at the end, it's in a concise format that you can simply compare on what those differences are. All right. When I talk about California, we have our rules of professional responsibility. We also have business and professions code. Okay, so that's the California rules. The other thing I'll tell you is you never need to cite to a rule number. There's a danger in doing it on the bar. When you look at the sample answers, if you mess it up, they don't think you know what you're doing. What they care about is that you've identified the issue or the duty. Okay, so keep that in mind. So when you look at the BarWinners approach and it gives you those topics, those are your checklists to be able to identify in the essay, has the lawyer breached a duty? In this section, not on all sections, but in this section, if you give the bar examiners one extra duty, it's not going to hurt you. So if you see an issue and you're just not sure, okay? For instance, on the duty of competence, that probably is on every essay. Does it need to be? Maybe not, but if they breached a professional responsibility rule, they probably breached the duty of competence. Okay, that's an example that if you threw it in, because of the above breaches, there might be a breach of a duty, you're not going to hurt yourself. Okay, they're looking to see if you know what a lawyer should do in a situation. The model rules are the general rules adopted by many states. Okay, they're the standard, and then states can differ. Right? Sometimes California and the model are identical, and you'll see that, right? Sometimes there is no difference. Other times there's a big difference, and so you want to certainly highlight to the bar examiners that you know that, right? The other thing you're going to see when we get to the essays at the end is that they're very short, okay? They give you a situation of a lawyer doing something, and it might be typically a few paragraphs long. So you should feel good. These are easier than your law school exams that went for pages, or hypos in practice or anything like that, okay? The key here is not missing the issue. Since it's so compacted, we don't have the luxury of missing issues, all right? And the only way to get good at spotting the issues is you will read the outline, we'll go through it tonight, and then you should write or at least issue spot some essays. That's how you test, am I getting the appropriate things. Okay, so let's start. Go ahead and get your information out, and we'll just kind of walk through. The one thing you're going to find that this really is in a different order than probably what you did in law school, right? It's actually a much more, I think, logical order, okay? And why do I say that? Well, we start with getting the client. In most law schools, if they covered advertising, it was at the end, right? So let's just flip to the BarWinners and not the approach. Let's actually, We can start with the approach for a minute. I'll highlight a few more things. You want to make sure you're not dealing with malpractice, as most of you know. If it's a tort, it requires a tort answer. Here we recognize it's professional responsibility because it says ethics or professional responsibility in the call of the question, okay? So that's the first thing that you want certainly to highlight. Okay. Getting the client. This is the advertising area. As I said, in most law school classes, absolutely they do this towards the end. Some don't even cover this in great detail. This is a very, very simple area. I used to say when I lectured for Bar Review that really it was not that testable. But then in the last few years, they threw it on a few times, all right? And so it's not difficult. And it used not to be testable because the bar viewed it as really a consumer testing area. It's consumer law. But since they have added it, I want to make sure we're covering it. All right. The main thing in this area is if you see an advertising issue, it's allowed under the Bates case. The Bates case actually said that you can advertise. It's regulated by commercial speech, okay? And so you're allowed. So you can see when we start going through the essay at the end tonight that commercial speech is allowed, advertising is allowed. The key is that shall not be false and misleading, all right? That it absolutely shall not be false and misleading. All right, so what does that mean? You want to look for anything that has presumptions of guarantees in California that actually looks like it's a dramatization, right? Anything that they say no fee or cost that was on a bar previously, okay? You don't want anything that the client can actually say, I didn't quite understand that, or that's not correct. You also don't want to say you specialize unless you're certified by an organization that specializes, okay? So if I say I'm a specialist in construction law, I could actually be cited by the bar because there is no construction law specialty. I could say that I've been rated highly by a group of lawyers that only do that. I could say my practice is only in that area, but I can't say I'm a specialist unless I'm actually a specialist. And that is a term that has been certified either by the state bar or by an organization. So that's pretty easy. Typically, some of the local bar review, county bar associations will have special training and they may give you some type of certificate. You may not be called specialist, but you may be certified by the LA County Bar that you've completed this. So you would need to say that. You don't need to say specialist. You need to say whatever the organization was. Another good one would be, many of you will be in this organization, the Trial Lawyers Association. They have a lot of different certificates, okay, that you get a specialty in advocacy, okay? They just had a training here where you put in a full week and you got this specialty. You'd have to say you're certified by the Association of Trial Lawyers and you have to be technically correct, okay? Because it raises the consumer view that you might have more experience in what you do, and what the bar wants is that it's not false and misleading. So I would literally take whatever language you're given and say that, okay? Typical certifications in California, as you probably know, are things like workers' comp, family law, tax. There's some specific areas that the state bar will certainly come in and regulate on. But construction wouldn't be one, real property's not one, and that's where lawyers tend to get in a lot of trouble, okay? All right. This area I will cover quickly because I'm going to come back to it, but your approach also says, in this area, consider looking at loans to clients, all right? Where this comes up is where you try and actually advertise that you're going to give the client something free as part of your advertisement, all right? And again, you shouldn't be doing that as part of the advertising material. You're not really allowed to do that. There's specific rules on loans to clients, and it wouldn't be permissible to advertise that. For instance, a lawyer saying, I will pay your rent if you hire me, is not going to be permissible under the advertising rules or the rules on loans to clients, okay? So keep that in mind. I think most of you would know that. This is definitely different than solicitation. Solicitation is one-on-one, in-person contact. Okay? So advertising is more, you can target it, you can mail it, it can be on a billboard, right? But when you do it in target mailing, that's something else, okay? Direct solicitation is not allowed. Offering a gift if they hire you is not allowed, okay? So you want to be very, very careful, certainly, in that. Obviously, any cappers or runners, which are people that maybe work at your firm or you hire to go get the advertising, is not allowed, okay? Now, let me give you a real-life example, because I'm sure you know how the essays are written, is lawyers are paid several years before, minimum of 2 years. You get paid when you submit a question, and then if they accept it, you get paid more, all right? And typically, a lot of the questions can come from current events. So in this area, several years ago in the West Valley, there was the Metro Rail link crash, okay? And what happened is people were killed. Right? Lawyers were disbarred as a result of that in the advertising area, which is why you could see something like that. What they did is they sent cappers or employees out to the crash site. They sent them to the funerals of the victims. Okay? Well, the state bar, our bar, actually sent investigators out to all the funerals. And all the lawyers that sent a capper or went themselves was disbarred. Okay? You can't get around it by saying, I'll have someone else do it. Okay? And so again, you want to be very careful. Now I give you that hypo because if the bar wrote it that they had a billboard saying, I have done many train crashes. If they took an ad out in the LA Times that said, over 30 years exclusively practicing in train crashes. If that was true, that's okay. If it was true, they'd have to prove it. It cannot be false and misleading. If they said they were a specialist in train crashes, they can't say that. There is no specialty. Okay? So you want to be careful. They could advertise. They did in the LA Times, they did on the billboards. There's nothing wrong with that. All right? It's when they violate it, and certainly when they go to solicitation. So no false and misleading, and no one-on-one contact. Okay? Very, very important. Yes? A capper is the same as a runner. It's someone that goes to kind of get the case for you. Yeah, ambulance chasers. Yeah, that's a great way. So a capper, basically, yeah. In the real life case, it tended to be secretaries or paralegals, and they sent them out to all the funerals. Why? There was a lot of funerals. And so the lawyers didn't go themselves. So let's say there were some famous cases where there was factory explosions, and they sent people to sign them up outside, okay? Again, ambulance chaser is a great example. You're signing them up. Have you ever seen some of the Grisham movie? There's one movie with Matt Damon and Danny DeVito, and he calls himself a para-lawyer because he's waiting for bar results. And he sits in the hospital. Okay, that would be a capper, all right? He is trying to sign people up. And so, again, the bar, that's where the bar doesn't like it. It'll be very obvious to you because they'll say it's a one-on-one in probably an accident scene or people laid off work, and the lawyer doesn't go, but they send someone. Remember, we have a general duty of supervision. We cannot order someone to violate our ethics code and say, well, it wasn't me. It wasn't a lawyer. No, you can't. No, you can't. You can speak. You could go to a public hearing and speak and give your card and leave it on the table, right? There's actually an example of that. And they could come up and take the card. But if I walk up to you and give you the card and say, why, I want to be your lawyer, now I violated it. It's the one-on-one solicitation, all right? And so it's going to be obvious to you in the fact pattern. And the bar doesn't like that if it gets closer to solicitation. Advertising they're comfortable with. They just don't want it false and misleading. All right? It's very comfortable with advertising. Right? The only way you're going to have a violation on an essay on the advertising is they said a specialist, they said they did this for 30 years and they didn't. They said something false. Okay? That's how you're going to see on the advertisement. Otherwise, that's not so testable because the bar doesn't get a lot of complaints in that area. They get it when you're out harassing someone doing one-on-one solicitation. Okay? All right. The next area is beginning the lawyer-client relationship, duty to avoid frivolous claims. When I say frivolous, no basis in law or fact. So, there's been bars in several other states where it's said in the fact pattern that this is a difficult case to prove. There's only a 20% chance that you could prevail. That is not a frivolous claim. Okay? No basis in law or fact. It would probably be something that the client told you that the statute of limitations had run, all right? And you still sued. That's a frivolous claim. Unless you could find some tolling or some way around it, right? So we don't want the court system being taken up on cases that have no basis in law or fact. The most recent common event, in case something's written, is some of you may have known there's a law firm in Beverly Hills. And it was a group of graduates from law schools that hadn't been practicing very long, and they started suing Korean business owners. They sued them because they had just come to this country and for various things. And what happened, many of the cases, the people just paid it off. They settled. And it turned out that one business owner said, no, I am not paying. I'm going to hire a lawyer and I'm going to fight it. And turns out it was an entirely frivolous claim. All right? And so the state bar actually disbarred those lawyers for that. Right? They looked at a pattern and history of it. So it would be a very vivid example. Not an iffy case. Not you only have 20% chance of recovery. Or it's an uphill battle. That's not a frivolous claim. I want to be clear. Okay? Not at all. So that's not what they're looking for. Okay? In our California rules and in your oath for the state bar, you have to maintain actions that are just or cause. Right? So obviously, if there's no basis in law or fact, you're certainly not going to take that. Okay? So not a big area for the bar, but again, I'm going to cover each topic just so you're aware. Okay? Attorney fee and client funds, big area for the bar. Big area for you in practice. Okay? Why? It's provable. They can tell. Okay? If you mischarge, overcharge, borrow funds, they can tell. It's very easy to prove. Competence is harder to prove. Some lawyers would say, I think that lawyer did okay. Not in this area, okay? And so, again, we want to take a look at it because it's easily testable, and it's a simple area. The main thing in this area, and I think on page 12, it's very clear in this outline, the key you're going to have to determine on a bar question many times is the fee reasonable? Okay, that's what the model rules say. California says it shall not be unconscionable, and guess what? They're actually dealt with the same way. Okay, so when you see the bar questions and you start going into answers, a really good bar answer would say, in California it shall not be unconscionable, and the model rules shall not be unreasonable. However, they're interpreted the same way, and they come into this list of factors that's on page 12. And so you're not going to like this, but you should memorize these factors. There is a risk if they give you a question that you're going to be what I call conclusionary, right? This area of law is not that hard, but there's a tendency to jump to a conclusion, okay? So let me give you an example so we would see this. So let's say they give you a hypo of an uphill battle and you quote a 60% contingency fee in this fact pattern. Is there a problem? Well, when the bar has done that, students conclude, yeah, there's a problem. Remember, what they want here is just like every other area, they want IRAC. The issue isn't unreasonable or unconscionable. That's what we're looking for. The rule here is we have to go through the factors: the time and labor, expertise in the field, preclusion of other employment. Okay? What that means is you gave up the potential for taking a case. The best example is Johnny Cochran and a large fee on the O.J. Simpson case. Why? He cleared his calendar. And so he could charge more when the state bar looks at what he's charging because he gave up work. Okay? The nature and the length of the professional relationship, how sophisticated you are, how long you've known the client. Time limitation. Boy, Johnny Cochran, drop everything because we're going to have a trial in 2 months, and it's a murder trial. Okay? A lot of time constraints. Fees charged in the area. What do other criminal defense lawyers charge? Is it fixed or contingent? Okay? Meaning, you know, how much are you charging for tasks? How much are you charging overall on the case? And an overall reasonableness. This should be on some type of flashcard for you, right? Because when you see fees, I want you to think, this is how I analyze it. I have the rule, reasonable, not unconscionable, and you go through it. So my 60% hypo, you're not going to conclude it's too high. Okay? Many times you may not have complete facts to know. You're going to say the key here is, and I go through these factors, and you may say, I need more information to determine this. We need to know the standard if the state bar doesn't give you that. But you have to know these factors. Yes? Okay, so the question is there some number that automatically it would be unreasonable? The answer is, for purposes of the bar, no. For purposes of practice, sometimes there'll be a state statute that tells you what you can do. And so if you're violating a state statute, then it would be unreasonable. An example I'll give you is probate. When someone passes away, it's a percentage of the estate. So if you're actually the probate lawyer, you don't get to say, I'm going to charge poor, you know, Auntie M $3,000 on a $3,000 matter. Okay? The probate code legislates that. In the workers' compensation area, they mandate that the plaintiff's lawyer only takes a certain percentage. Okay? So unless there's a statute for practice purposes, for the bar, they're not going to get that complicated. Remember, it's a few paragraphs. They just want to see if you know these factors for the fees. Okay? So again, if you were starting your outline, this should go on some type of flashcard. You have to know how to analyze it. Yes? That's what I would do. They're like subheadings. And if you, very short. They're very short. Because the bar's giving you a few paragraphs, so you're not going to have a lot of information on, they're not going to give you what everyone's charging in the area. They're not, you know, they're not going to give you that. But they need to know that you know how to approach it. All right? So again, you should know these. By the way, this is in our California code. It's also in a famous case called Wheeler. So usually I get asked, well, do I need to know case names? No, it's the same as the codes. You don't. If you knew them, when you know, and you're really that confident, you could throw it in. But I'll tell you, in the ethics area, the only time I've seen really names is Bates, which is the advertising case. Sometimes Wheeler on the fees. There's very few, a few in the confidentiality area. But that's over the history of me looking at bar exams for 20 years. Most just identify the duties. Okay? Because there's that risk that you're stressed out and you say the wrong name. It's not Bates, it's Cates, and they have no idea what you're talking about. So it's just better to keep it simple. Okay? All right. Another unique thing to California, our model and California, if you see contingent fees in this area, they have to be in writing. So when you see contingent fees, must be in writing. In California, if the fees are over $1,000, okay, you also have to put it in writing. All right? So you must. We have no choice there. There is exception for if you're a corporation or an emergency. So 2 exceptions there. Right? But if they give you a number, probably you're going to make a comment. So they're either going to make it under $1,000, and then you'll see that the sample answers typically say, we don't need it in writing because it's under that. or they'll give it to you for $1,200 or $10,000 or whatever. If they're giving you the age of someone, it probably means something. So pay attention to the numbers, all right? And you'll see that, I think, in the, one of the hypos you're going to do tonight is Betty. And when Betty comes up, they're going to make the son 18. So they're taking out issues, all right? If they're putting a number on fees, they're probably adding either this rule that it should be in writing in California, or they're taking it out, one or the other, okay? The written fee agreement must have an hourly rate, the general nature of the services, and the respective responsibilities, okay? So keep that in mind. If a lawyer is let go, you'll see in this outline, and again, this outline is very good, very detailed, it says that you get quantum merit. This comes up when it's a contingent fee, all right? So it doesn't really come up so much in your hourly rate, but what do I mean? You get in a fight with your client and they fire you, but you've put 2 years of your life into this. You took it on a contingent fee, okay? Obviously, you want something out of it. The courts provide that, subject to your retainer agreement, you would get the fair value of your services. So court would have to come in and look at that, and that happens all the time, all right? You have a duty to render statements on how you're going to be billing, and that's also a general duty of communication, okay? All right, fee splitting. You cannot split fees, and this area is a little complicated. You can't split fees in the model rules at all, okay? What do I mean, right? You get a case in, and this is a true fee splitting case. You get a case in, you're out of law school, you're in your own practice, and it turns out it's a family law, it's a divorce. You don't do that, you do commercial law. But your friend from law school, she does family law. You refer it over, and she gives you a fee back, whether it's a referral fee or a kickback, okay? The model rules say you cannot do that. You can't do it. California allows it in limited situations. So any of you going into practice, depending on your area, this could be very lucrative, whether you're referring or you may be paying out fees, okay? That the total fee to the client is not increased, and that it's in writing, all right? And the client doesn't object to that. All right? So the example, our state bar, the reason that we have that, they don't want you keeping a case outside of your subject area. The model rules say it gives you incentive to get rid of cases and to give it to just anyone that's going to pay you a fee. So we have very different philosophies. So that's a true fee splitting. I am not talking about a hypo where you're brought in as a special tax lawyer or the bankruptcy lawyer and you're doing one aspect of the case. That is allowed. You're billing for a separate type. It's not really splitting the fees. It's separate billing, all right? We're talking about a referral fee situation on the bar. Now, this isn't tested very much, but it is unique to California that we can do it if it's in writing and the total fee is not increased and the client is fine with it, okay? So it could come up, all right? But well, so it's nowhere I know of in writing or a rule, but the standard is about 10% of the value of a case. And I don't know, that's what real lawyers do. So if they sent you over a car accident and you were suing for $1 million, you really thought you were going to get $1 million, it might be that 10%. Typically, they don't pay it out until they get the recovery, okay? So it kind of varies. Where you'd have a problem is the lawyer refers out, and it says in the hypo, she normally charges $200 an hour, but on this case, she charged $300. What she's doing is recouping that fee. Now we have a problem. We even have a problem in California. Okay? Even if the client consented, the total fee has been increased. Okay? So again, haven't seen this much on the bar on this referral fee, but keep that in mind. You're looking for almost a kickback situation. Okay? Fees with non-lawyers. That's sharing your fee with a non-lawyer. To give you the background, that came about because we had a lot of international lawyers coming into the country. They don't meet the requirements, and typically what will happen is they join with a lawyer that's licensed in California. They do all the work. When the case ends, they want their part of it. They could hire them as a paralegal, but they can't be sharing fees. Otherwise, it's the value of your law license in California. You're working hard to pass the bar, and if you could just do that and get the fees, no one would be sitting and dealing with the California bar, right? The best example I can give you is two recent ones. One is TV fame, Aaron Brockovich. Aaron Brockovich was actually a paralegal. True case. State Bar looked into this. When they won that settlement, she got a $1 million bonus that was publicized quite a bit. And the State Bar looked into it. They said, this looks like a fee given to a non-lawyer. And they said, no, it's based on the profitability of the firm. Okay? Where they would have gotten a lot more trouble is if they had a lot more paralegals. It was a very small firm. If I changed that and there was 4 paralegals and only 1 got the bonus and they all worked on the case, it really looks like you're sharing it with 1. Okay? So you want to be careful of that. The other is the case that you're probably aware of, the Glassman case that is up before the California Supreme Court right now. He's trying to get bar admission. He's a famous journalist. And he, probably is going to lose, is my opinion, but he's trying to, even though he lied and fabricated all these stories, he says he's rehabbed. So he's arguing for the State Bar that he should be admitted. He works at a law firm in Beverly Hills. Okay? He's a super paralegal. He's paid better than the other paralegals, but he probably has a law degree. He's probably much better, right? If they were to start giving him $1 million bonuses and no one else, all right? That hasn't happened, probably, because they're watching him pretty closely and he's trying to abide by every rule. That would be a problem, okay? You don't want to share a fee, anything that looks like you're sharing a fee with a non-lawyer, all right? It'll be obvious in the fact pattern, all right? But if it looks like some type of hidden bonus and no one else is getting it, it could be simply something like this. So we want to be really careful about that, all right? And by the way, that's why the State Bar over the years they're redoing these rules right now, but where lawyers that wanted to be partners at accounting firms had to have different titles than lawyers, because it was sharing fee with a non-lawyer if you went to an Arthur Anderson or something like that. All right, so a lot of people that actually went in that area, they were crafting titles that are different so they wouldn't violate this rule. Okay? Contingent fees. This is where lawyers get in trouble in practice. So it's heavily tested on the State Bar. Remember the purpose we started with. They are testing this so you'll be more ethical. So if a lawyer's getting in trouble in this, it's probably going to show up on the bar. Okay? All right. And by the way, there's a controversy. The sole practitioners say the bar comes after sole practitioners. All right? But in my view, if you're at a firm, so many people are looking at your work product, you're probably not going to get in as much trouble in this area. Right? Contingent fees must be in writing. Okay? That's the first thing. The second thing that's a big difference, and when I get through the lecture, I'm going to come back and we're going to walk through that chart, all right? But this should be a big star because this has been tested and tested and tested, okay? Model rules prevent you from taking a contingent fee in a criminal defense or domestic relations case. They don't allow it, okay? The best example I can give you, let's say it's your lucky day, and you landed Mrs. Trump, number 3, number 4. And she hires you and she says, I don't have a lot of money, but why don't you take my divorce on a contingency fee? And you say, yeah, I'll take that. And you're working hard and you're working for about 1.5 years and she calls you up and she says, good news, me and the Donald are getting back together. And you say, no, you're not. I'm on a contingency fee. I'm not supporting you in this marriage. I want my percentage. Model rules comments say they want to preserve marriage, and so they don't agree with taking domestic relations on a contingent fee. They also don't believe in it in criminal, which I don't know how you could really structure that, your fees reduced if I only get you a life sentence. I'm not really sure how that would work. Okay, so they say no. So it'll be very obvious to you that the lawyer took one of these types of cases. California says go for it. You can. So if you see that, that's one of those areas that you're going to be highlighting. Okay? We talked about the fee splitting was a little different. This area is a little different, all right? And they have tested this quite a bit, all right? So they obviously want you to know you can. California's view is the lawyer should be able to quote any case on the contingency, and it shouldn't be a problem, all right? So again, you want to look for that, okay? You'll see that in California we have a few additional requirements. That's on page 13, and that would be that it's in writing, that it's negotiable, and that the client is informed that if they're doing a fee agreement in a contingency, they can consult with independent counsel. All right? Okay. All right. I already covered this, but again, I'll cover it again. Remember, you want to be careful that a contingent fee is still evaluated on those factors. Don't conclude here. It still has to be subject to the reasonable standard. Okay? All right. Another big area I want you to star, next big area, loans to clients. Okay? The model rules say no loans to clients unless they're poor and you advance it. If they can't afford you, indigent clients, you can do it. Otherwise, we don't want you in business with your lawyer, all right? California said they're not improper always, okay? They're not improper always. California is after employment if in writing. After employment if in writing. Now, I'm sure most of you would understand this, but since I've seen lots of ethics students, when I give a test, mess this up, I'm going to tell you what they do. They assume that after employment means after you're done representing them. No, after they've hired you. So that rule should be kind of rewritten in California. After they've hired you, if in writing, you can lend them something. Okay? So let me give you a pretty vivid example. It's from a real case. Let's say you had a client and she was actually attacked at USC. She was leaving the campus and she was attacked, okay? And really injured, okay? And very scared. And she interviewed several lawyers and you gave her the fee quote and you said, I've done a lot of these cases and I've done premise liability, and she hires you. And then about a few weeks into the case, she's so distraught with what happened, she loses her job or she quits her job. And she says, you know, I need money for rent. You could lend it to her if you put it in writing because you've been already hired. But let me change the hypo. Let's assume you're interviewing and there's other firms interviewing and you say to her, if you hire me, I will pay your rent. You can't do that, okay? After they've hired you, if in writing, you can loan the client money. And obviously you want a reasonable term. You're not going to, give them some unreasonable agreement. The model rules say indigent or tied to the case, directly tied to the case, you can advance costs. So for instance, in a model rule jurisdiction, you could advance costs if it had to do with court reporter fees or things like that, okay? And then at the end, it comes out of the case, right? But very limited in the model rules. California, it's a free-for-all once they hired you, okay? So they have tested that several times. Why I guess it's unique to California? They think you should be able to help your client, even if it's not directly related to the litigation. If she can't afford rent, and you really think it's a good thing for her, you should be able to loan her money. Okay, so they're not going to come in and micromanage, but they want it in writing, and they don't want that to be the decision why she hired you. Okay, so you want to be careful on that difference. You should be putting a big kind of star next to that. Okay, all right. Client funds. This is tested, but it's simple. Can't commingle. They have to have their own account. You can't borrow for 5 minutes the money. It doesn't matter. It's not dispositive if it's for 5 minutes. Okay? They're separate. And I want to be clear about this so you know, in case, and I'll talk about this at the end, in case there was some crossover. A lawyer that steals a client's money, even if it's for 5 minutes, would be certainly a violation of the rules of California professional responsibility and the model rules. And it would be a criminal violation for some type, depending on the amount of grand theft. Okay? So they would have a criminal action against them, and they'd have the state bar action that would easily take away their bar license. Okay? So this is a big deal. It's a big deal. And they go in, it's easy to prove. All they need to do is show that you took the money for a short period of time. Okay? So they keep a separate trust account, that money stays separately. You have to have records. You have to have an accounting upon request, whether to the client or the state bar, or if you're transferring the file out. Okay? And they better be complete. And if the client leaves and is any type of fund, you have to give it back to them, subject to your retainer agreement at that time. Okay? All right. Fee disputes. If there's anything disputed, and this happens typically in a fact pattern where they're firing you, and you can't just delve into that account. So let's assume the client has $5,000 in your trust account. Client says, I don't want you anymore. You can't just go in and take that money at that point. You owe me money. You can't. It needs to stay there if it's a disputed fund. All right? And that means you got to be very careful. You also can't threaten them. I'm going to keep this property or do this unless you pay me. Okay? You can't. You also don't automatically get out of the case if they're not paying you. You have to get a court order. I don't know which performance you'll be writing, but there's a famous one called Richardson where the lawyer thought he could get out of the case simply because the client stopped paying, and they gave you the codes in the performance section that basically showed you had to make a motion and get court permission. All right? And you'd have to actually show that. Okay? California has a unique arbitration provision. You'll see that also in your handout here, that basically says 6,200 between lawyers is voluntary for the client, but mandatory for the lawyer. So if the client wants to do it, you have to do it. All right. The next area is competence. Again, this is an easy heading, because if they violated a rule, they have violated their duty of competence. This is harder to prove for the state bar, all right? So you're not going to see it as much on the bar exam. If a lawyer is going out of their practice area, there's probably a heading you want to give them on duty of competence, okay? You can go out of your practice area, but it doesn't mean you can do it badly, all right? So you'll see in the Betty hypo later, she takes something out of her practice area. There's no problem with that, but you have to be competent. You have to come up to speed on it, okay? There is no requirement that competence is tied to whether you are charging. So the one kind of loophole on the bar is if you're doing it for a public interest organization, pro bono, it doesn't change your duties, and specifically not your duty of competence. You can't say, I tried less hard because, they are not paying, or they're paying a reduced fee. So don't fall into that trap. Don't fall into the trap. You can't take something out of your practice area. All right? When you look at the factors, again, on page 19, starting at 18, they'll go through and they'll basically deal with the complexity, your experience, the training, the preparation, essentially the facts of the case, and look at your ability to handle it. They will give you a little bit of a break if it was an emergency situation. Okay? Again, what would an emergency situation be? 9/11. A lot of lawyers went in to help and didn't charge on various probate issues, insurance issues, and they didn't do a necessarily perfect job. That's the one time probably that they're going to let them say, you know what, we think you were competent given the situation. All right? But that is very rare. That is very rare, that emergency exception. It's the only time I really think I've seen it used, okay? Because again, there was a victims recovery fund and everything else. And so again, if you were incompetent in criminal law, you may have that crossover with ineffective assistance of counsel, okay? Again, not doing your job certainly correctly, all right? All right, The next area is diligence, moving the case forward. Model rules and California require it. Okay? This comes up also with the duty of communication. And so you have a general duty of diligence. Look for things that have to do with delays. If someone's purposely delaying something, they're probably violating that duty. Okay? Communication. Both California and the model rules require a general duty of communication. So if you see the lawyer not responding to correspondence, not returning phone calls, not keeping the client informed of what's going on in the case. Again, in your hypo with Betty, you will see that. Okay? They're not telling the client what's going on. They're simply sharing it with the other lawyers. So you have a general duty of communication. Any significant developments. In this duty, the client gets to pick the substance of the decisions, and the lawyer gets to do the procedure. And you probably remember that from law school. Okay? So, if it's motions, typically the lawyer is deciding. But if it's a settlement offer, the client gets to decide, right? I think most good lawyers keep the client informed on both, by the way. But for the bar purposes, okay, if it's substance, you better be consulting with your client, all right? So they can make an informed decision. Okay, other areas, settlement offers. Model Rule 1.2, a lawyer receives a settlement offer in a civil matter or in a criminal case must promptly inform the client of the substance before taking any action. And California is any offer of settlement to the client in a criminal and any written offer in a civil proceeding, right? So in California, there's a slight difference on that, just a slight difference there, certainly on the written offer of settlement, right? So what do I mean? You're on the phone with your client or opposing counsel, and you think it's a $100,000 case, and the other side comes back with an offer, and they give you $10,000, right? The ethical duty is to communicate to your client that you got a settlement offer. They verbally said it to you. What happens to many lawyers is they say, I'm not even going to my client with that. That offer's so low. California says once they put it in writing to you, you have an absolute obligation to do it. So a good lawyer would say, I know you turned this offer down, but per our conversation, here is a written offer of settlement that must be conveyed to your client. You do that to make the lawyer have an affirmative obligation, okay? So that's why they put it in there, because so many lawyers are so dismissive in that area. Or if it's in criminal law, under either you would need to tell. Okay? All right. Now, most of these make perfect sense. Right? Any questions so far? How you could blow this area is the conclusionary. Okay? That you just conclude one way without doing the IRAC that you're going to do in all the other areas. That you always tell yourself, here's the issue, here's the rule, and apply it. You just conclude because it seems so obvious. And again, I look at when people don't pass the bar at Loyola, many times they'll come to me, and what I see is they just jump. They just jump from one thing to the other, okay? Or they don't know the law. On the reasonableness, they just didn't memorize the factors, okay? So it's not just that they were so confused. The third way is they don't identify, and I'll talk about this when we talk about corporations, they don't identify who the client is. They identify duties that goes to a different person. So if there's multiple parties in any of these fact patterns, you want to ask yourself, who is the client, right? That's going to come up the most, by the way, with any corporation, because the corporation's your client, not that individual that called you. So if you start talking about the duties to that person, you've blown it. So there's some really basic things you have to do in this area, but they're important. And I'll certainly remind you as we go through. All right. You'll see some issues on if you're going to contract away liability on page 24. And certainly in California, you can't unless they're informed in writing and they seek independent advice. And they're given a reasonable opportunity to seek that advice. Okay? All right. Unauthorized practice of law. You should be licensed in the jurisdiction, or at least pro hoc vice, where you're allowed by that jurisdiction to come in and practice for this time only. Okay? How this could come up is you're on the internet giving advice all around the US, but you're not licensed. You have to look. If it's a general advertising thing, you're fine, but if you start engaging and giving specific advice to someone in a different state that bar thinks is legal advice, you could be in trouble, all right? You can't have non-lawyers practice law. You're going to see that in our Jones hypo. You can't let them. Again, they're protecting the value of your law license in California. It's good that they're doing that, right? And so we'll see. Typically, if it's anything to do on the bar with settlement offers, going to court, they don't like paralegals, law clerks doing that. If it's interviewing and fact-finding, looking at documents, they're fine. And so every time it comes up, that's kind of how they divide it. So the rule here would be no unauthorized practice, and you'd go through each thing the paralegal is doing and conclude, is it more like practicing law or is it not, okay? And so actually there's an excellent list on 22 if you look at that. Fact investigation is fine, witnesses may be proper, negotiation gets much closer to improper, settlement meetings, improper, signing off on the documents, actually executing them, not allowed, but drafting them and someone reviewing them for someone else's signature, sure, that happens a lot. I'm sure as a law clerk you've done that too, all right? But the non-lawyer needs to be supervised by the lawyer, and so of course there's a general duty of supervision. So that paralegal that's doing something, you have a general duty of supervision, okay? Any questions on that? That's a really easy testable area that, again, they do a lot. Because they don't want you delegating without supervising. And again, if the premise of the bar is to protect your value of your license, you'll see that they want you doing the legal work, and they don't want the paralegal doing it without your supervision, okay? Any questions so far on that? I think on the Jones hypo that comes up quite a bit. And again, you'll see that if you start looking at the ethics essays, these themes, you're going to see when your outline says it's testable, oh, there it is again, there it is again. So they keep testing the same issues in this area. It's not tricky, per se, right? All right, duty of confidentiality. Believe it or not, this is simple, all right? California and the model rules differ in this area. Let me give you a little of the history. California, up to a few years ago, said you could never tell no matter what. Never. And model rules said if someone was going to have serious bodily injury, you could. Someone's going to be hurt, you could. You may. Under either set current day, you don't have to. I want to be clear about that. There's no ethical obligation. No ethical affirmative obligation. Right? In fact, they want to protect confidentiality. But you can, in California, if someone is going to have significant bodily injury. Okay? You can. Model, there's no obligation. No. So if a client comes in and says, I am going to go kill my boyfriend, I just have had it. Obviously, I try and talk them out of it. Okay? But if they do it, you have no obligation for the ethics purposes to warn. Okay? You may under other laws, tort liability, but under the ethics you don't. Okay? And if, again, you're at risk for it, because if they were just blowing off steam and someone reviews it and you did tell, they'd have to say, did it seem reasonable that he or she thought they were going to do that? Okay? So you want to be careful about that. It's a very, very limited, yes? Well, there may be under tort. Yeah, there may be. Well, right, it's kind of that, it's a little bit like the Tarasoff case, right, in torts, which is more the therapist obligation. They'd have to prove it, and confidentiality would have to be waived. But I'm just saying, I'm speaking of the ethics now. Yeah. In the tort, there may be potential. I'm not saying they'd prevail, but there may be. The best example I can give you is a case that was on 60 Minutes not very long ago. And it was two lawyers that represented a criminal defendant. Criminal defendant said during the representation, boy, Mr. X that's sitting in prison, what a joke that is. He didn't do that killing, and he's in for life. I did it during the course of the representation. So he confesses to something that someone has been sentenced for. The lawyers try and persuade him in California to go and do the right thing. And he says, I'm not doing the right thing. I'm not doing the right thing. So, well, he's in prison for life. It's this man's life. Of course, you see these cases all the time now on the news. And he said, I'm not. But I will give you an agreement that if I pass away, then you can tell. And so the lawyers went to the state bar, and they asked the California bar. They said, so, we're not going to tell you what client it is. We're not going to tell you any names. We have this hypo. Can we breach this because we think this is serious bodily injury? And the state bar responded, no. If he was on death row, yeah. But he's not. He's life in prison. You cannot tell. So they didn't. Fast forward 20 years, he dies. They bring it forward. Everyone goes crazy about how these lawyers are unethical. The truth is they were entirely ethical. They could not breach it unless it was serious bodily injury. The only thing that I kind of object to is, to me, that's serious bodily injury. But the state bar did not feel that. So what I'm talking about is an extreme case, right? The model rules also allow it if it's a serious financial issue, right? So they'll allow some breach. So for instance, in something like the Madoff case, they would allow you to tell. California is much more limited in what you're going to tell. And under either, you have no affirmative ethical obligation, all right? This is the cornerstone of our profession, right? So I tell them the differences, but don't be so quick to jump on confidentiality, okay? So kind of different. Now, this is a little different in one area, right? Because I'm talking about confidentiality. We also have a general duty of candor. Now, the problem is, on most of your duties, they don't conflict in California, right? They don't conflict. Advertising's not conflicting with competence. You're not really seeing that so much. This is the one area that conflicts. The court's saying, don't lie to me. Okay, don't lie to me. And yet they're saying, you know there's going to be false testimony. Now, most of you probably remember these rules because they're covered usually in evidence, criminal law, and again in professional responsibility. Okay, they're covered in 3 areas. Interesting. If you see this, tell the bar that I have a general duty of candor, and also tell them you have a duty of confidentiality. There's one major issue here, so let me put it in a fact pattern perspective. The client says to you, I'm going to go on the stand and lie tomorrow. Under either jurisdiction, you try and talk them out of it because they're going to perjure themselves. In California, and then if they insist on it, you tell the court. The model rules decisions say that candor trumps confidentiality in that. Our decision says confidentiality still is preserved. So again, I'm coming back with how strict California is. Right? This could be some type of crossover for criminal or for evidence or for something like that. All right? It's not on the bar as much as you'd think, but you understand that this is the area that you have your general duty of candor. Pretty simple. Tell the truth to the court. And yet it conflicts with this. And it's usually someone getting testifying on the stand, and you know they're lying. So there's a little bit of a difference. You had a question? You ignore it. Yeah. You can't do it in your closing remarks. It means you couldn't do it in any conclusory brief, like they say, we want this issue brief. You can't mention it. Yeah. Tell me what occurred. That's what you do. Not leading them, okay? And you let them just talk, all right? Right. In the model rules, you always talk the client into doing the right thing, and you attempt to withdraw. You just say, the client and I are not communicating. And then usually it's denied in real life and in the bar questions. And then you tell the court, basically my client's not being truthful. Candor trumps confidentiality under the model rules in that decision, And in California, it does not. It does not, okay? So that's another, and the reason I keep highlighting the ones that are different when we go to the chart, I want to make sure that you just get, because those are the testable things. The other duties you'll know, okay? Duty to communicate is the same under both, right? Fees, unconscionable and unreasonable, same, just same factors really. Not much of a difference, except in some of these other areas. Yeah. Yes. So I love that point. So the question for those of you that are watching this also is, if the call of the question just says discuss the ethics rules, do you discuss both? And I was really shocked because a few years ago, usually they're really good on the call to question. They say model rules in California, and they bring you right to it to remind you. But a few years ago, they just said ethical rules. And I was talking, and I won't tell you who, to a big bar review company who called me after the bar results and said, can you imagine, they just said ethics rules. We lectured and told them, if it says that, you don't really need to worry about comparisons. And I said, no, you got to look at the preamble to the bar and the whole history. They want the comparisons, of course. And so the students in here did very well because, yes, it's an excellent question. California model rule comparison. I don't care if the call to the question says ethics rules. Now, I've never seen this in the history of the bar. But if they said, do not discuss the model rules, then don't. Do not discuss California. I haven't seen that. Okay, I have not seen that. And that would be rare. Okay? I think they just messed up on the call and they figured, well, everyone knows the ethics rules are the ethics rules, right? And but what happened in that is the big providers, people did one or the other. They didn't know which one to do. The whole goal of this on here is to see that you're a good ethical California lawyer. And it's California specific subject. We have our own rules. So if there's a difference, you want to discuss it, right? That said, sometimes there isn't a difference. General duty of loyalty, general duty of communication, general duty of competence, okay? You're not seeing it. And so you're going, well, there's not a difference on this particular ethics essay. And there may not be, right? But if you see contingency in domestic relations or loans to clients, confidentiality, you're going to see probably a difference, all right? And so you want to bring that up. So don't overthink it. There may only be one California difference on your essay, right? That is possible. It's not like every single one is a California difference. It's just they tend to test those in the historical value of the bar a little bit more. Yes. So the performance on the bar, okay, the performance on the bar, if it's in ethics, they give you everything that you would need to answer that question. And typically they give you the California rules in some California cases, although it's called the State of Columbia. But typically you may recognize it, right? On that section, okay, they're seeing, not that you could memorize the rules and know like you know the factors here. They want to know, can you follow directions and can you apply it? Can you follow directions and can you apply it? So if you remember that and they say another lawyer in the firm has dealt with model rules or another lawyer has dealt with this issue, you do not at all deal with it. All right, I always give this example to my students. I had this brilliant evening student, really smart, did very well in appellate law. She worked at a law firm, paralegal, the whole time in law school. And she came to brag to me after the performance section. She said, I really nailed it. They had to do an intro to an appellate brief. My lucky day. And it said, someone else in the firm is dealing with standard of review. Don't put it in there. And she said, those bar examiners, they're so stupid. Of course you have to put it in there. So I put it in. And I thought, oh my God. She did not pass. And she did not pass on that section. Do not, that is following directions. That's whatever is in your file you do. And that's where you should all, by the way, take a deep breath, look around the room and say, I can follow directions, so I'm going to nail this section. Okay? Because that's what it is. Absolutely, because they told her not to. The call of the question said, do not do this. Someone else has done it. And remember the purpose of the performance. It's to see if you can get it done under time pressure, but it's also to see if you can follow directions. That's why they started the performance. And it's hard when you're stressed out. I'm not saying it's easy, but that's what they're looking for. So by her adding it, they thought she couldn't follow directions, right? So we want to be very careful, right? You haven't had your performance lecture yet, I assume. Oh, you did? Okay. Because really that task memo is kind of like, you know, your roadmap to that. And whatever it tells you to do, you do. Okay? In my view, the only way to really blow the performance is to either not understand what the task memo does or to really mess up on your time management. Okay? To doing it under time pressure and figuring out, can I read and analyze the first hour and a half and do I start writing? That's the thing on there. It's not the law. On this, you have to issue spot. The way to blow it on this is, like I said, you just didn't spot the issue, okay? Or you didn't know the law, right? So on this section, pretty clear. And so again, we'll look at the Jones at the end here too, okay? So again, if it's the candor versus the confidentiality, I want you to see that you have a divergence here, okay? Because we do have a duty, you know, to not put this forward, okay? The only other exclusion here is self-defense. If the client is suing you, obviously for competency or various things, there is going to be exclusions where, you know, you can't just be boxed into a corner and you can't defend yourself, okay? In California, if you look on 25, a lawyer may reveal confidential information if you get informed consent likely to result in the death of or substantial bodily injury, okay? And it must be done to prevent the act, okay? So this is not a past crime, that's the other thing. The hypo I gave you where I'm gonna go home and I'm gonna kill my boyfriend. If she came in and said, I killed my boyfriend, it's past. There is no exclusion. Get that? All right? So you want to be careful. Again, I'm going to emphasize it's limited in California. All right? It's got to be imminent, right? And so again, you really, if you're going to have to reveal someone, you want to really kind of document it and everything else. All right? A lawyer is not permitted to reveal confidential information on a client's past. All right? So obviously, I think you know that. Fruits of the crime. Again, straight from your con law and probably criminal. And I don't know why this confuses people, but if you see a weapon, and by the way, this never happens, but they come in and they give you the weapon and the fact pattern. Client says, here's the weapon, or here's that watch I stole during that robbery, okay? Typically what you do is you keep it for a reasonable time, and then you have to turn it over to the prosecution. You can't hide it, you can't dispose of it, you can't direct them to throw it out, okay? Right, so, could you go look? Client says, I threw the weapon in a dumpster. You could go look at it, you can't move it or you're destroying evidence. You can't alter it. Your investigator could go take a photo of it, but once he or she takes it, now you've altered it, all right? And then they could comment where it came from at that point if they knew, okay? So it's interesting. You have to be kind of careful. And again, not as testable, but you're looking for something where they're doing a crossover and they're throwing it into a dumpster, they're bringing it to your office, something pretty dramatic, all right? But you can't just reveal it. You can't go to the DA and say, this is what occurred. You would just say, it came into my possession, and here you go. I kept it for a reasonable time. By the way, a side note, just trivia, defense lawyers say this never happens, and if it did, they don't know what a reasonable time is, okay? So no one really knows what that would be. But if you did see it on the bar, you just give them the rule back. Client gave you the weapon, kept it for a reasonable time, and you turned it over. I think it would be there'd be reasonable protocols, although that's not necessarily in the rule. The rule simply says you keep it for a reasonable time and you turn it over. Okay. You don't have to do anything with that because you didn't alter evidence. I mean, frankly, I'd just be careful that someone wasn't tracing your investigator or, out there looking. Right. That's it. That's it. Yeah. That's the thing that no one knows. No one knows what a reasonable time is. And besides the rules not telling you what a reasonable time is, it was my mission when I'm teaching ethics to ask criminal lawyers. And they're like, we don't know because this has never happened. And a lot of them will say, a week seems reasonable, but a month is too long. But, that's based on nothing. You say nothing as a defense lawyer. Yeah. Now, let me just vary it. Prosecutors have special duties. So they have a duty to reveal if they knew where it was. But defense do not. Okay, so keep that in mind. I guess it's kind of like a sports event. It's fair game. But when it's a prosecutor, they shouldn't be going after people that didn't do the crime. So that's kind of the difference, all right? So, but you can't hide it. Obviously, you have a duty not to conceal evidence for your client. Next area, conflict of interest. Big on the bar, big in practice. Now, if I was to tell you the one area that could be confusing when I'm dealing with students studying for the bar, for some reason it's conflict. Okay? And I'm going to try and give you some simple approaches tonight. All right? But for some reason it is conflict. The first thing I want to kind of give you just some advice on, when you start looking at sample answers on the bar, you're going to see duty of loyalty. Duty of loyalty is the same thing as a conflict of interest. I prefer duty to avoid conflict of interest when I'm teaching ethics, but the truth is the bar interchangeably uses them. Okay? So if you go, well, this is a conflict, they put duty of loyalty. Their sample answers sometimes say conflict, some say duty of loyalty. They're the same. Avoiding a conflict of interest is being loyal to your client. Okay? Now before we go through what's in your handout, a conflict of interest typically relates, and I think the easiest way to remember this is more than two. Okay? This is your traditional, meaning you have a former client, a current client, and you. Okay? More than two. In your Betty hypo, you're going to see lots of people. Probably one of your headings is conflict of interest. Okay? So if it's more than two, why the lawyer should have that relationship with the client that comes first. And when there's a former client or someone else is giving direction, there's a conflict of interest. Now, for some reason, the bar loves this traditional kind of fact pattern. And this is what it is. They'll cross it over with family law, or they'll just have it as standalone ethics. They have someone else paying the fees for the client, and they don't tell the client. So several years ago, they had a single parent that was in a custody dispute. And what happened was, she didn't have a lot of money. The lawyer came in and felt bad for her. And instead of her normal rate of $200 an hour, charged her $75 an hour. The grandfather heard about it and said, I'll make up the difference, but keep me in the loop. Okay? We have third party paying fees, but we have a general conflict of interest. Who is the client here? She is the client. All the duties go to her, not breaching confidentiality with the grandfather, right? So you want to determine if there's more than just the lawyer and the client. There's multiple parties. You're going to look for conflict of interest in the fact pattern, and you're going to identify who the client is. Okay? So for instance, in your Betty example, you have the mom controlling things, all right, and the mom paying, but the kid who's 18 is really the client. And remember, the fees don't create the relationship. Okay, they don't create the relationship. So you're looking for that. So if it's more than two, you want to start out by identifying who the client is. Because how you could blow it here is think that the payer is the client, and then you start talking about all the duties that you're really going to identify that you get, but it's to the wrong party. And so the problem with that is you've gone down the wrong path. When you see a corporate entity on the bar exam, you want to identify who the client is. So again, another example of this conflict. You have dealt with ABC Corporation for your career, but John Kelly is the person you always dealt with. He's the one that always sent you the business. One day he calls you up and he says, I need your advice. Why don't we meet? You get together and he says, they fired me. I need you to represent me. Who is the client? The corporation. You can't take that case. It's a conflict of interest. We have more than two. You have the corporation, the individual, and you. We know it's a conflict, all right? But where you could blow it is start talking about the duties with him. He is not the client. Okay? Another one that they did a few years ago, long-standing fact pattern that you have been drafting loan documents for ABC Corporation. Okay? This time, John Kelly is your contact again. Okay? You've been doing it for years. He calls you up and he says, boy, you've done good work for me, and thanks for this recent loan transaction that we're still negotiating. I put 3 kids through college and I got to get my 4th. I've been skimming money off these deals you've been doing for me. Good for you. Okay? Students start going into confidentiality and all this stuff. No, who is the client? The client is the corporation. Your duty goes to the corporation, and you actually, on your general duty of communication, would have to tell them what their employee said. Okay? But what do people do? They go down the we owe this duty to him and blah, blah, blah. No. Who is the client? So when you see a corporation, make sure you know who you're representing. You see multiple parties, who you're representing. So there's usually going to be 2 headings there. Who is the client and some type of conflict of interest. Yeah. Well, he didn't know in the way the question was written, but the answer is no. If he called and said that, you'd have to say, I represent the company, I can't help you, I don't want to hear anything. Yeah, that would be appropriate. But if you always met him, I need to talk to you, meet me here, long-standing client, I can see how that would happen. You still have the same reaction, I can't talk to you. Okay? For purposes of the bar, though, I told you this area is not so tricky. You want to identify who the client is before you go down the duty road. And the area they can trick you in is if there's corporation or multiple parties. Remember, fees are not dispositive. So by the grandfather paying the bill, either partially or 100%, she is still the client. He cannot be kept in the loop without consent from her, and it didn't say that. So if the lawyer went on to tell him what's going on and not tell her about the fees, we have a problem, all right? And you'll see in here, on the bottom of 27, third party paying fees, okay? We really shouldn't be accepting fees from someone else, okay? Unless, and this is exactly what we've just talked about, client consents, there's no interference, and confidentiality is preserved. So again, I'll get to you in just 1 minute. I want to emphasize that you star that in your outline, because I'm not sure why they test it so much. Okay? I'm not sure. Maybe it's in the area of family law or immigration or areas like that that lawyers are getting in trouble. They must have some reason, but it's on there a lot, the third party payer. Yeah, your question? Yeah, I think the appropriate thing is to say, very generous offer. I need to circle back to the client. I need to get their full consent. And confidentiality will only go to them unless they waive it. Okay? And then tell her he's willing to pay, not this secret in the hypo that they never disclosed it. Okay? And so then if she said, yeah, I want my dad informed here, get it in writing from her, and then you can keep him in the loop. All right? I'm going to come back to again, because again, this is the only area that worries me for the buyers, this conflict. More than two. Other ways that they get you on this is the multiple parties. So it comes up on crossovers from trusts and wills or torts, right? Why? A hypo is that you've represented this client for years. He was in a horrible car accident with his family. He calls you and he says, I want you as the lawyer, and can you represent the whole family? Okay? Which makes sense because it's the same car accident. And he says, this is what happened. The answer is more than two, so we have a conflict of interest. You could get a potential waiver and you could represent them because they're not, at this point, in an actual conflict, right? It's multiple parties. You always want to get that waiver. You find out in deposition that he was on drugs. It was his fault. Now, I don't know if they're going to sue him, but technically, okay, whether it's friends or family, they might have some cause of action. You have an actual conflict at that point, right? So it can come up that way. And by the way, you don't pick your favorite client, which is where someone gets conclusionary. You don't pick your first client. When there's an actual conflict, you don't represent any of them, okay? Same way with the trust and will. When they had it on there, a family comes to you for help during the probate, all right? The mother or father died and they left it to all my kids from Joan. Any child of mine and Joan's. And so it turns out later during this probate that one of the kids has a different parent, has a different mom, and no one knew it. You have an actual conflict. You have a problem. They're going to be disputing each other. Okay? So that's when you see a probate, a tort, a multiple party. That's going to be very obvious that probably one of your headings is conflict of interest. Okay? All right, so you understand that. It doesn't come up a lot, but it's super easy to identify. The other is not as easy to identify. When nice grandpa is paying the fee, people miss it all the time. No, that's fine. It's not fine. It's more than two. There's more players than two here. It's a conflict, right? And you better tell them that you recognize that, okay? You'll see here a great job in this outline in who is the client, the corporate entity, best interest of the corporation. Again, that could be easy corporate business association. And I've given you some good hypos on that are real life, okay? All right. Sometimes a lawyer has a dual role in a corporation. Sometimes they'll give you the general counsel. The general counsel still reports to the board of directors. Okay, so they have duties that definitely go that way. The outside lawyer has a duty to the corporation as well, all right, not to any individual employee, all right. Under Chadbourne, the privilege does not apply when types of corporate employees communicate with the lawyer. So you have to kind of look at, are they in the group that is actually assisting the lawyer with the litigation? Are they former employees? Again, you want to look at who the client is and what that person is acting in the capacity of. Okay, all right. The other conflict I call is a personal conflict. It's between basically the lawyer and the client's interests, all right? So it could be as simple as a business transaction with a client, where you talk the client into something that would benefit you, okay? There was a question years ago where the lawyer talked the client into buying a boat with them, okay? Well, if it's fair and reasonable and everything else, that's fine, but you better put it in writing, because if it influenced how you did something in your client relationship, you could have a conflict of interest, okay? Another good example of this would be, there's a case that they haven't tested out there where the lawyer was suing for the client on $1 million case, and the client, when they got the settlement offer at $500,000, said, I'll take it. And the lawyer said, no, there's more money to be made here. Don't take 50 cents on the dollar. And the lawyer said, you know what? I'll give you the $500 now. Assign me your rights. Conflict of interest. Can't buy a case from a client. Why? Maybe you're advising them a certain way to get this situation. So you have to be very, very careful that you shouldn't have any interest in the subject of the litigation. Now, of course, when you have a contingency, you do have it. That's just a reality, and they allow that. but the buying of the case has been deemed an actual conflict of interest, okay? Let's say you want to go into a business deal with your client, and it's all on the up and up, all right? You'll see on page 30 that it better be fair and reasonable. Client must be informed in writing of the deal, and in addition, they should be able to inform in writing that they can talk to independent counsel, okay? Full disclosure on items, all right? So again, probably not a good personal thing to do, but it may occur. There is a unique rule in California that has never been tested, but I'm going to mention it. I think it's in your chart, but it's not right here, so I want you to just write this. You cannot buy, even with client's permission, property at a foreclosure sale. Okay, even with client's permission, foreclosure or judicial sale. Right? You would probably know that, but it's never been tested. But since it's a unique, minute rule to California, I want to make you aware of it. Let me give you the example. You're meeting with your client, you're a business lawyer, you're giving them an advice on how to avail themselves of different short sales, foreclosures, bankruptcy, and the client says, I had multiple properties, and where are you looking? And you say, oh, I'm looking in Studio City. And the client says, you know, I have a beautiful home that's going to be foreclosed next week there. Well, I'd rather have you have it than some lender. Get in there and bid on this. You can't do it in California, even if it was a fair and reasonable deal. Okay? Never tested, but I want you aware of it, because since it's so unique to California, and since we had so many foreclosures 3 years ago, someone could write something, all these questions come up because someone writes something that they read about, right? You can't do it. It's a conflict of interest. Model rules don't prevent it. They simply say, if it's fair and reasonable and in writing, you're fine. So they'd come in and look at whether it was fair, all right? So again, a little bit of a difference. That's one that I think California lawyers got in trouble on, and that's why we have that rule. Yes. That's different. That's different, yeah. They're looking for the conflict between you and your client. And if you get compromised based on you coming before the client, that's where you get in trouble, okay? All right, and same thing with book and media rights. You shouldn't be negotiating for the book and media rights while you're doing the representation, okay? It's the same thing, all right? You want to be very, very careful. Sex with clients. Same thing, okay? Same thing. Interestingly, how this came up on the bar several years ago was based on a true case. The public defender was having sex with a woman that was accused of killing her husband based on domestic abuse. He wasn't having sex with the client, he was having sex with her daughter, who was of age, 18. And again, I saw people writing no sex with clients and this is a problem. No, it was really the general duty of competence. And was there a conflict of interest, a general duty of conflict of interest that they were violating because he wasn't doing the job he should have done? Their problem was they didn't identify the client. The rule goes to sex with clients, not sex with their family members. That can impact your general duty of competence. It could still be a conflict, but it doesn't fall under this specific rules, okay? So pay attention. Remember, these paragraphs are so short. There's a tendency to quickly read them. And on the essays, usually the hour is enough. Okay, where you mess up is if you're spending too much time issue spotting, right? So make sure you identify who the client is. That's really the crucial situation there, okay? Obviously, if it's pre-existing, it's your girlfriend, your boyfriend, your spouse, you know, it's not subject to this rule if it's a pre-existing relationship. It may still not be a good idea, by the way. Okay, you may have kind of a general conflict that doesn't fall under this because you're too emotional, right? But it doesn't absolutely fall under that rule, okay? Gifts from a client. Great crossover with trusts and wills, okay, on page 31. Great, all right, just a great thing Lawyers shall not solicit any substantial gift, including a testamentary gift, or prepare a will or instrument giving the lawyer or a person related something substantial. So if you saw something that they're giving you 2 tickets to a movie, I'm not worried. If they're giving you 2 tickets to the Super Bowl, we have a problem. Okay, so use some common sense. But again, don't be conclusionary. Say, it's a conflict of interest here, okay, to get a substantial gift. Here, this was given if the court deems it substantial, which is more likely than not, or likely or not likely, all right? Okay. We come back again, that's how important this is, on providing finances to a client, okay? So we dealt with it under fees, and now we're dealing with it under conflict of interest. So if you're giving them expenses, as I said, litigation expenses, no problem. Rent, okay, after employment if in writing, all right? Family relationships between lawyers. This is just, again, these are all general conflicts of interest. Obviously, under the model rules in California, you disclose if your family member's on the other side of the case. The only thing I would tell you difference here is California required more disclosure. If you were living with or intimate with someone, you let the client know, all right? So let's assume you get out of law school, you're living with your law school buddy, and he or she's on the other side of the case. California says, yeah, you should tell. Model rules say, no, it's only family members. Okay, I think California is better. I think in most instances, we would want the client to know that, okay? All right, so a general duty of disclosure. Lawyer as a witness, yes, if it's very uncontested on an issue. The contract was executed. Something happened on this date, but not substantial on the case. Because remember, you're a witness and you're the advocate. That said, this is the one area that someone else from your firm could take the case. It's not really transferred over. So if you have a personal connection or you have to actually rely on some substance, okay, you should not be the witness on the case. Okay? All right. I am now on page 33, conflicts between clients. I talked about the trusts and wills, and I talked certainly about torts, that once there's a conflict, you can't represent them. I didn't mention former clients, okay? Former client, they better be truly former, and you have no unfair advantage here. Then you could certainly go after them, right? So it's pretty fact specific. So the way it came up on the bar is you represented Joe as a business lawyer for many years. And you incorporated his company. You gave him financial advice. You gave him advice on assets. You haven't billed him or done any work in 5 years. His wife calls you and says, you did a great job for him in the past. We're divorcing. I want you to represent me. You're truly a former client? Yeah, you haven't billed him in 5 years. Do you have an unfair advantage? Probably. You know where all the assets are. You know what they're at. So you probably couldn't take that case. Okay? Could you ask Joe to give informed consent? If he consented and a third party would think it's reasonable, you could take it. Probably it's not going to be reasonable under that hypo. Okay? All right. Criminal defendants, as you know, are very difficult to jointly represent because one could blame the others. Right? So you're going to have a big conflict in that area. 1.7 says attorney would violate ethics if she represents joint defendants because there would be a conflict of interest. Unless, and if you look on page 35, it gives you adequate representation, full disclosure, and would a disinterested lawyer agree? Okay? All right, so pretty clear here. And California is similar, all right? The only thing that's different is it wants you to confirm that in written consent, okay? All right, former clients, full disclosure, would a disinterested lawyer agree? All right, okay. Government lawyers, obviously, if you're at the government and you don't want to sue them in a firm, they're going to be disqualified. Okay, it's going to be imputed to the firm. You can't be doing that, all right? You have to be very careful. All right, page 37, duty of candor. We covered this, but you have a general duty of candor in California and the model rules, okay? Again, the only time you would, you can't lie to a court. You can't lie about, I have a prepaid vacation. You can't lie about case law, okay? Do you have an affirmative duty, though? You know the other side missed a key case in a civil proceeding. No, you're absolutely right. They're saying no. You have no affirmative duty, okay? You'd only if it was absolutely on point, and you're never going to see that. What do I mean? The exact subject area, okay? No way around it, and the court wasn't aware of it, okay? That really almost never happens. So where it could happen is if the court just didn't get what the statute of limitations, and there was no way around it. It would have to be something extremely vivid. Again, you're coming back in this area, the thing we already covered on the duty of confidentiality, all right? And the testimony. That's also on 35 and 36. So what I like about this outline, it kind of deals with it in one place and it comes back again, because as you see, we need to know it for confidentiality, but you also need to know it for duty of candor, okay? Other things, general duty to opposing party and counsel, all right? You have a general decorum, obviously. 6068 of California says you shall not be obnoxious, all right? And that's what this is getting to, right? So it's a general duty of fairness, right? You have a general duty to the profession. California is a self-reporting jurisdiction, meaning the lawyer, if they violate the rule, would report themselves. The model rule, people tell on each other, okay? If you actually saw a rule being violated, model rules, affirmative duty, California self-reporting under 6068, okay? By the way, every year I call the state bar, not a lot of people self-report, all right, as you can imagine, all right? But we do have that affirmative duty. Okay, we're going to kind of wrap up the rest of this, and then I'm going to bring you back to the chart also so we can review. Ending the relationship, mandatory, permissive, withdrawal, okay? If in fact there's a knowing violation, your ability is impaired, there's an actual conflict, or you're absolutely discharged by the client, you have to actually bring a motion to withdraw, and it would be mandatory, all right? Other areas, with the exception of these, are permissive, meaning you can ask to get out or not get out, okay? And so again, if the client used your services to do something that is bad and in the past, not current, you certainly can, you may withdraw, okay? The client is too aggressive, and you're not. You don't believe it's right for the case. So they have something you just can't agree on. You may withdraw, okay? This will result in a financial burden to you, i.e. they're not paying you. You may withdraw, meaning you request. You don't automatically get out. And so general good cause, you feel like this is not going to be a good situation, okay? And typically you argue this to the court, you bring a motion, and it's up to the judge if he or she will certainly let you out, okay? All right. If you violated any of this, right, well, the remedy would be the state bar could come after your license. That would be the remedy. They would do an investigation and they could come after your license, right? There'd be a disciplinary hearing. They could issue sanctions, okay, a fine, right? They could suspend you, you probably know that, for a period of time. They could reprimand you, meaning they publish your name in the State Bar Journal. There's also legal malpractice issues, which would be a tort. So if they're asking you for tort remedies or malpractice, it's not pure ethics, okay? It's under tort, right? And so those are really the remedies, okay? Things like malicious prosecution and abusive process. And again, that would be under your tort area, okay? Your tort area. All right. Again, the key in this area is to figure out who the client is, who the duties are, and then if you look at the chart, and again, this is, you're lucky because I'll tell you, I look at a fair amount of bar outlines, and they're not as clear as this. So it's your professional responsibility chart. It basically says ABA on one side and California on the other, all right? And so I asked you tonight to highlight certain areas, right? They're all on here, but some I've identified as more testable, right? And so one thing I would think that you'd want to do after tonight's lecture is take the notes and go back to this chart and kind of go through it and highlight the confidentiality, the areas that are different on conflict, the loans to clients, okay, the referral fees that we talked about. California, you can do it if in writing, total fee not increase. Okay. Those are the big differences, the candor versus confidentiality. Right? And again, why? Because there's not a lot of them, but those are the testable ones. And then if you're coming back to review this, because again, bar review, as you know, is very quick. We do this, we're going to go through Jones, then you're going to go through Betty, and in reality, you're going to be moving on to a new topic, right? So what you may want to do later on is come back to this chart. You won't have time to come back to everything. Come back, read through the chart, and maybe go through an issue spot, some additional essays, as the bar certainly gets closer. Okay, but you see this is very well organized here. Kind of walks you through each and every difference. Okay, contingent fee, another big testable one. Domestic relations and criminal in California, fine, not in the model rules. Okay, fee splitting, big difference. Confidentiality, right? The exceptions, difference. So you'll see all of these are really highlighted here. Some of the conflicts are the same. Financial assistance to client, again, different in California. Third-party fees, difference there. Sex relations with clients, very similar, except ours is a little weaker in that we shall not do it, but the exception for prior relationships, and also it basically says no sex for fees, so it's a little bit lighter where the model rules isn't. I'll get to your question in a minute. I just want to make sure I get to this. Relationship with other parties, lawyer, broader in California, okay? And again, on this chart, candor towards the tribunal, a little different, right? Advertising, really pretty much the same in both areas. We just have a little more detail on those presumptions. Okay. Areas of specialization, not much difference there. So the big areas you should literally take a marker to and highlight it, right? Because those are the ones that you want to let them know. The other duties you're going to spot. We went through and loyalty, competence, okay, reasonableness of fees, conflict of interest, because you're going to remember my rule more than two, okay? You're going to be fine. It's just giving that difference. California is interesting. On certain regards, we have more rules, like that judicial foreclosure, okay? Where they actually come in and they legislate a little bit more, probably because lawyers have gotten in trouble. But on that, they really believe that you should be able to, as a business, take whatever case you want. And it's kind of a business model. Whereas the model rules say, we're not going to let you, we're going to prevent you because we just think it's bad news for you doing that. And we don't want to deal with it later when you get in trouble with your client. They actually kind of let you do it. And I think they have a little bit more just, we're not going to over-legislate that. That said, where we're really strict is on the confidentiality compared to other jurisdictions. And up to a few years ago, we were the most strict. You just could never tell. So it's interesting. How I think the rules evolve is where lawyers get in trouble, and maybe California is not that worried about that, okay? They're just not that worried about that area. Yeah, they believe you should be able to choose. Now, there is an argument here. I want to be clear that our state bar, I testified before the state bar last summer, and I just went up to see the changes. And their big concern, and this may be helpful to you, is that over 90% of the cases in Los Angeles Superior Court in domestic relations, people can't afford lawyers, that they're unrepresented. And part of it is, if they had a rule that you couldn't take it on a contingency, I'm sure it'd be 100%. The only thing that gets people through is, you know, my spouse has X money, I can't pay you now, but at the settlement you can have some of my house. And so I think they do care about representation. And the model rules say, no, we're not allowing it. The criminal defense, I'm not sure I understand because we have public defenders. So we have an argument there that I don't know why, you know, if you want to take it on a contingent. I mean, a lot of people, no, it's our state, but I'm saying they allow it if you were to enter into a private relationship. But I'd say most poor people are going to use a public defender. They're not going to get a private lawyer. Who's going to get a private lawyer is the uber rich, to be honest with you. Most of us couldn't afford a private lawyer. They're really expensive. You almost have to be in a situation like the O.J. Simpson, where you have a whole team that you can afford. It's not a normal professional person affording a lawyer at $300 an hour. So it may be access to the system, I don't know, but it's interesting. That's the state bar. Currently, their big worry is about people in family law having no representation. And so they're coming up with all sorts of proposals. By the time you are out there in a few months, it's interesting. They want to do limited practice licenses. You might be able to take a bar just for family law. You don't want to take the whole bar, and you could just do that. They're coming up with all sorts of different proposals over the next few years to get access to people in this area. All right. I would have thought it would have been in other areas, landlord, tenant, or no, but this is the area they're concerned because the stats look so bad. So just kind of an interesting thing that in the next few years you may see that you could just take a bar in that one area, but you'd only be authorized to practice in that area is their proposal. So you'd just be a family lawyer in California. It'll be a very short bar also. It would have to be traced back. And you're right, most criminal lawyers take cash up front because they're not going to get it later on. Right? But for purposes of the bar, you need to be careful that you know these key differences in this area. So again, I just went through them, but that chart is really your guide and roadmap to this area. That, in addition to the essays you wrote tonight, it would be in probably doing a few more. And you're going to see conflicts on there each and every time. And so BarWinners is going to give you a lot of questions, but the State Bar website also has questions and answers. So if you wanted even more in an area, they're identified. Okay? They're identified by professional responsibility. And so you could go to the State Bar and go back several years and print some. Okay? And as you know, they have an answer A and an answer B that are a little different, that shouldn't stress you out. They have that, so you know there's not just one set way to do this, okay? So that would be my thought. All right, I want to talk about Jones. So I know you have the Jones. So Jones is a little tricky. That's what I like about Jones. A little bit tricky. Right? So someone want to read me the first two paragraphs so we're all on the same page with this? Have a volunteer to just do the first two paragraphs. And again, those of you watching it on tape, get out your professional responsibility, question Jones and Smith. Not many, not many. And more sole practitioners. If you look in the State Bar Journal, in about each month, there's probably about 20 lawyers mentioned. Okay, so if you do that times 12, you're looking at 200 something. We have thousands of lawyers in California. Okay, so not everyone's in trouble. Many times the lawyers, by the way, it coincides with another issue, a health issue, a marriage breakup, or a drug and alcohol issue. Okay, and things start spiraling out of control. It's more that. You're not going to see, and most of you will be thankful, brand new lawyers out there, newly licensed, that are incompetent and getting their license taken away. That's not it. It's mostly on fees and conflicts of interest, and it's because they borrowed the money because they were in a bad situation. Okay? All right, Jones. Someone want to just quickly read me those paragraphs? Okay, stop for a minute. They're just identifying you to this. And this is, I like this essay because it's a good example. Is there any issue here? So a law firm that wants to increase business. No, absolutely right. There's no issue here. Okay? They're introducing the problem. That doesn't always happen. Sometimes they throw issues in, but here a law firm can take steps to increase it. It's a matter of if you can do those steps. Okay, the next paragraph. Okay, stop right there. When you see a TV ad, you're always going to tell the bar, what? What do we know about a TV ad? It should, yeah, it's clearly advertising, but you can do it under commercial speech. They're allowed to do that. Yeah, right. And again, I don't think you need to cite Bates, but in the limited times I've seen cases, sometimes people are, you're allowed to do it under commercial speech. Okay? There's nothing wrong with that, but it must be what? Not false or misleading. That's your rule there. Okay? So that's what we're looking for. You tell them, look, bar, I know. We can do this. It's legal under commercial speech. No false and misleading. All right? So that's that. The advertisements will state that while most firms charge 33%, Jones will charge 25%. Any problem? Absolutely correct. You have to be able to substantiate. It has to be not false or misleading. So I tell the bar, there's nothing wrong with that if it's true. And this is one of those examples you can't tell from the fact pattern. If it's true, they can do that. Nothing wrong with that. Okay? In addition, the advertisements will state that the firm offers interest-free advances against prospective judgments in cases of clear liability. What is that? Okay. It's right. And the problem, you're absolutely right. This is another one of those loans. It's just they called it something different. Okay? Their advertising will give you a loan prior to employment, right? So I tell them the model rules has to be tied to litigation. In California, you could do it if in writing, after employed, right? Here, we haven't been hired yet. I think we might have a problem, all right? So great issue spotting because, again, while I like Jones, most are more upfront than this. This is one of your harder ones. This is a disguised loan. You're absolutely correct. Okay? Second, the firm plans to acquire from the police department lists of individuals who've been involved in auto accidents and to mail the letters to those persons informing them that they're available to consult. Okay? And then they're going to send flower arrangements to the hospital, compliments of Jones and Smith. Okay? All right. Let's start with the lists, because when this was on the bar, I saw a lot of the Loyola students, and they missed this and blew it. When they came to me and they weren't successful, they said, of course you can't do that. Don't read into the fact pattern. They acquired lists. Can you do that? Yeah. Right. Right. If nothing in here says it's illegal, they would tell you that. They'd say, they met Mr. Blue under, the shady code and bought the list. They're going to give you a fact like that, okay? Here, if they legally acquired them, you can get the lists, okay? And so all the time people get lists from things these days, as you know, right? So there's nothing wrong with that, all right? How about sending the letters? Can you do it? It's targeted mailing. Yeah, they've allowed it, okay, but they can impose restrictions. Obviously, you can't harass or anything like that. So you can do a targeted mailing, right? What about the flower arrangement? This is really tricky. Okay, this is a different, they're sending it compliments. Well, let's take it one step at a time. We have you're absolutely right, but let's take our advertising hat. So the first thing is, it appears to be advertising, okay? And any advertising mailing must be labeled, all right? So it should have said advertising material. And the second thing is, the question that's unclear, is it more like a solicitation? Because it's a little more than just getting a letter. And if the bar thinks it's a solicitation, then you can't do it. And so I'd tell them that, all right? I'd say this seems more like a solicitation because you're actually going there. And the person's vulnerable under our California presumptions and some other things, right? But certainly more intrusive, right? And so it would have to be labeled at the very least, and it might be more like a solicitation. Well, this is a little different, and let me tell you. Under the Metro Rail, either the capper or the lawyer shouldn't be out there. Here it's interesting. If I change this fact pattern, which is why they made it complicated, and said the law firm delivered flowers, they couldn't do that. That's a person-to-person contact. But here it kind of indicates that the flowers were sent. So you called 1-800-Flowers and they sent them, right? So there's that little bit of difference. So if you look at the sample answers, actually your answers are better than the sample answers. They're more detailed. But the two answers for the bar when this came out, people said it must be not false and misleading. It should have been labeled, and it might be a solicitation. It seems getting closer to that, right? So that's a little bit different. But it was sent, remember, from like 800-Flowers. It wasn't sent by the lawyers. If I change it and Standing DeVito delivering them, we have a whole different scenario, just like the Metro Rail. That's in-person contact from your law firm. All right? Yeah. No. I'm saying there's two issues. If you view it just as advertising material, at the very least it should have been labeled. But I think it's closer to a solicitation, so it's prevented. So under either analysis, it's wrong. Even if you were liberal and said, I don't think this is a solicitation because it's from 1-800-Flowers, it's still a problem it's not labeled. So under either scenario. So I tell the bar both, because the reason I like this, it's not clear. It looks more like a solicitation to me. But if you look at the sample answers of the bar, I think one concluded definitely and one concluded it wasn't, and they were okay. That's why they made this a little gray area. It would have been a clear violation had the law firm brought them, but that's not the facts, okay? So what you're doing is you're trying to analyze which is it closer to, and I'd give them both, right? Which is what your sample answer did, yeah. It all depends what it says and how far it goes, okay? It depends if they acquired the list, right? It all depends. If they got it illegally or if it's more harassment, all right? But you're going to see in your lifetime, I get targeted mailings all the time, right? And the key is if they're labeled. I'll give you a really quick example that you'll like, and it's kind of visual. There, I used to live out in Northridge, and there's this area out by Rockadime, and all the dogs were dying. People that hiked out there with their dogs. And then what happened is the people got cancer after the dogs did, probably because the dogs were closer to the ground, and then the people started dying. Well, I lived out there, and then I moved. And then I got a notice from many law firms. We're representing anyone that was in this area during this time period. And we are basically targeting you, and it said advertising material, because you lived here. And we take these cases and we're based out here. Nothing wrong with that. Now, if they didn't label it advertising, then that would be a problem. Can they not send that letter? No, they can. Can they put an ad in the paper and say, if you lived out here during this time, you might want to check with us because you might have a risk? Sure, they can do that too. Can they show up at my door with a card? No. Okay? So again, it's the sliding scale. No solicitation, advertising okay if it's labeled. So we want to look at this. We want to carefully give the bar what they want. No false and misleading, no solicitation, and decide which is it closer to. Again, both sample answers for the state bar were a little different here. So the state bar gave you a gray area, all right? So they were accepting both, but they wanted to see that you looked at both issues, okay? And some students, you know, some of the answers said, no, I don't think it's solicitation because it wasn't sent by the law firm. The other said it was. And it appears, as much as it stresses you out, what they're telling you is sometimes it's great, and we're going to accept either. I understand, but again, we want to be very basic when it's the essays, right? You want that analysis, but IRAC, what is the issue here? Advertising is allowed, not false and misleading, must be labeled. Here, not labeled, okay? Second one, is it closer to a solicitation? I think it is, and then it's outright banned. So you want to hit the issues in that area. Yeah. Absolutely. And don't stress out if you come out a different way, you're walking out of the bar and someone changed it. On their grading sheet, mostly it's did you hit the issue and get the rule. You're going to see that sometimes people conclude a little bit different. And that's why we have jobs, by the way. If the law was black or white and there wasn't arguments to be made, we wouldn't have a job. All right? So don't worry so much about that. You do need to hit the issue, right? So if you miss labeling it, you miss solicitation, that's something that now is fine. And I'm going to tell you, if you miss it in the bar review, when you go back and you do what we're doing, you won't miss it on the bar. All right? So when you're writing your essays and when you're getting feedback from BarWinners, you want to pay attention to it. Don't just say if they tell you you're doing fine, oh, I did fine, I'm not going to look at it. What if you missed a big issue and that's the issue that's going to be on your test? So you want to actually take time to look at the feedback they're giving you. All right? Don't just throw it away. Everyone in bar review says, I'm not good enough. I'm passing. Not good enough. Okay? Because it may be this issue that's on there, and that's the only issue you missed. So like a good bar review, they're telling you, you are passing. But we don't know what they're going to test. So you want to pay attention to what things you're missing on here. And then you want to do something active with it. You might say, hypo with flower scent could be, you know, advertising must be labeled plus solicitation. Do something active so you remember, okay? All right, I need to wrap up because we have someone else talking to me about Betty. The last thing is the easy thing, non-lawyers doing tasks, okay? And in that, several paralegals, investigators responsible, no problem, and then they give you this list that they love. And what you're going to do is you're going to take each of them and say, is this closer to the practice of law? So fact investigation's okay, witness interviews probably okay, negotiation and settlement not. All right, so you're going to actually go through and take each thing and say no unauthorized practice of law. If you want to throw in and the lawyer has a duty of supervision, that's fine, okay? Remember I told you, is that necessary? I don't know if it's necessary because again, in the original answer, one had it, one didn't. you're not penalized for an additional issue in this area, okay? I'm not going to say on the performance I have a whole different thing. No extra issues. In this area, you're not, okay? Right? So what I'm going to do now is I'm going to end, and again, those of you that are watching this, certainly it's jean.boylan@lls.edu. You may have some questions. If I can be helpful, certainly shoot me an email. I'll get back to you promptly.
The call to question, has Alice violated any rules of professional responsibility discussed? It's nice and broad, and that's, you know, as she talked about in the last question, it was a lot about advertisement, but this one is more just straight to the point. Let's discuss the duties and get into it. So can someone read me the first sentence? Okay. Great. Now the first thing I look at when I start a PR question is I identify the parties. Who's the attorney and who's the client, and do we have any other third parties? So let's get that up on the board. Who's the attorney? Alice. I mean, we give you the letters, so it's nice and easy for you. Okay, who's the next one? It'll be Clint or Chris or something easy usually. Todd. And then do we have any other third parties? Mother. This is important because this defines who your duties belong to. So in that case, who does Betty represent? I mean Alice. Todd. So all the duties are going to revolve around this relationship. So, oh, bless you. Oh. Well, this is difficult to answer. The call to the question is discuss, and in these types, as you see, you're just going to get into the duties, and you're going to structure your answer. Duty of this, duty of this, duty of this. So it's a little bit more difficult to do a chart going down. So what I want to do is I want us to read through it and kind of point out what duties we see as we go through it. So let's moving on to, can you read me the next two sentences? Great. So does that spark anything? Do you see any duties coming up there that might, great. But let's go a little bit broader. What does conflict of interest really fall under? Exactly. So you're going to want to put your first, this is going to be your first bullet point. And what is our rule for duty of loyalty? Yeah? It's just a general, yeah. Utmost loyalty. And then what you were saying, the potential issue that comes up under this is conflict of interest. That's where those come up. And why would there be a conflict? Yeah, so you have a third party attempting to dictate the case of the client. So this is a potential conflict of interest. You have to work out the facts to see if it's an actual conflict of interest. Yeah. set up what constitutes a conflict of interest and get in that, because conflict of interest is something that would impinge on that duty of loyalty. That's why I like to organize it under as a sub-issue, even though duty of or conflict of interest is always going to be the biggest issue you see on PR exams. But it falls under, you just got to give that little intro blurb about the duty of loyalty. Well, potential, former, and current conflict of interest all fall under the broader duty of loyalty. They're all things that are going to potentially affect that relationship with any client that you have. So, I mean, maybe you're considering sub-issue to equate to a minor issue. I'm just saying it falls under this bigger umbrella of duty of loyalty, because without the duty of loyalty, then there wouldn't be conflicts, because if I don't have a loyalty to have you as my client, then it doesn't matter if he's trying to tell me what to do. Does that make sense? Okay. So let's continue. So when there's a conflict of interest, what does an attorney need to do to get around this conflict of interest? Is it something that can be circumvented? I'm going to paraphrase you a little bit. So you have the attorney has to reasonably believe that they can effectively represent you in the event there is a conflict. They also have to disclose this conflict to you. Full disclosure. It's the big thing in any attorney-client relationship, is that you all have to communicate with each other. And then, as you said, consent. And that consent must be reasonable. And then just a little side comment about when you see calls of the question that say, has Alice violated any rule of profession of responsibility discussed? Unless it stipulates under California rules only, you should discuss any distinctions where applicable. Even if it is something, for instance, in conflict rules, California law is a little bit more stricter than the model rules, and there's a writing requirement that is also in there. But otherwise, the elements would be the same. So, yeah. Yes, that is an issue. Let me see how this is organized. Because that's a fiduciary duty issue. So that would be a duty of fiduciary duty. We're going to get to that. So we have conflict, and then you would go with fact. So we have fact that it's his mother, and she wants to get this resolved as quickly and quietly as possible. So she's putting pressure on the attorney to resolve the case as she wants it resolved. Moving on, the fact that what other facts in here would show that she's trying to influence the case? Yes. So you would put your facts quickly and quietly, and rehab, because those may not be in the best interest of her son in this particular case, right? She's not a lawyer. How would she know? And then there's also, as you said, the issue of the fees. So that can go into both areas, because a third party isn't supposed to pay for the fees of somebody else to ensure that it wouldn't interfere with the case. And then you also have potential, and then is there something that says there's an actual conflict? So let's go well, we can come back to that. The facts jump around sometimes. But you would want to put those two near each other, even if it's discussing the facts. I like to discuss them near each other, because then you remember to thoroughly discuss all your conflict issues and move on. So we'll come back to this and put a star. Next. Bob, do you want to? Although. Okay, do you hear any issues in that sentence? Exactly. Good. I like duty of competence because it's pretty straightforward. So it's kind of easy points to me. I get excited when I see it because it's a rule that should be ingrained in you since we're all entering into this profession. What is the rule for competence? Good. And I like that you use that phrase under both, because always compare and contrast where you can when in absent clear direction in the instructions. Now, what in the facts makes you think there's an issue with this? Is this something that can be resolved? Great, because you can always become competent. So you would include that. And then you can move on. Where applicable, there's a distinction. Give me 1 second, I want to double check my notes on that. I don't have a distinction in my notes. I can double check on that though. But as far as competency, I've always learned that they're interchangeable. Model rules in California use the same definition. You can interchange those. And if you're trying to like nitpick on like the phrase like words like diligent versus competent, like they don't mean the same thing. Yeah. Or there's a duty of diligence, but it's the same in both. It all falls under that. Yeah. Yes. You can use duty of competence requires an attorney to have legal knowledge, skill, thoroughness, and preparation as reasonably necessary. And if they don't have that, they can always become competent by doing appropriate research, because we all have research skills, or associating with an attorney that does have those skills. And it's the same under both rules. Okay, so let's go on to the next paragraph. Can someone read the next 3 sentences to me? Bill, do you want to read them? Great. Do you hear any issues in those sentences? So that pertains to the scope of the attorney-client relationship, right? Yes. So that's her associating with Zelda to get around the competence issue. I'm going to use this phrase AC. This just is my shorthand for attorney-client relationship. I'll have to keep writing all of that out. So check on this. Yeah. Exactly. Yeah. I'm going to skip ahead a little bit. What this has to do with is that this goes to scope of relationship, but it also goes to these issues overlap. I should have just read through this first. Fiduciary duty. We'll just write them out. And when you can bring on outside counsel. And as you read, she gave, well, can you just, let's read the rest, let's read the whole paragraph because this will aid our conversation. So as far as the consultation fee, there's distinctions in this area. So you owe fiduciary duty to your client. And when it comes to representation or consultation fees, you can bring in a third party and split fees, but there needs to be disclosure and consent. Big thing today. Exactly. Which goes to, I mean, that's why these relate to each other, as you were asking. Who asked that? So, under the ABA, the fees, and everywhere, the fees must be reasonable. And so you're allowed to split fees, but they must give consent. And it has to be proportional to the work performed. And in California, the minor distinction, anybody know? Yes, and what's the other word? What's always big in California distinctions? Has to be in writing. California likes to really hammer home that there's a writing requirement in everything that you do for the attorney-client relationship. So when I do these, I like to lay out the rules, and I always lay out the modern rule, which is the general rule, and then I'll add the California as a distinction. So I won't necessarily do, a header under the model rules, it's this, and under California, it's this. I will just say the rule, and then I'll say, and in California, this is the distinction, because it kind of streamlines your discussion and your answer and saves you time. Yeah? Oh, you mean as far as people finding out she's a potential client? as far as people, to clarify, you're wondering if people find out that Betty is a potential client, if that's going to be some sort of issue. I would have to double check, but my instinct is to tell you no, because there's also confidentiality rules with your bank. They owe you fiduciary duties because your bank's acting as a trustee for your money. Excuse me? Well, I can look into that for you, and I can let you know after class if you'd like. So let's move on to, I want to kind of tie this back in with the conflict issue, and then we can leave conflicts for the day. Actually, no, we need to read the whole thing. I wish that they would have put all the facts nice and neatly together, but they don't. Okay, so let's just read the rest of the essay. Lance, can you read the rest of it for me? Oh, we don't have it with you. Let's just read this because that way I don't have to skip around.
At a subsequent court appearance, the prosecutor offered to reduce the charge to simple felony possession and to agree to a period of probation on the condition that Todd undergoes a 1-year period of inpatient drug rehab. Alice asked Todd what he thought of this, and Todd responded, "Look, I'm innocent. Don't I have any other choice?" Alice, cognizant of Betty's wish to get the matter resolved, told Todd she thought it was Todd's best chance. Based on Alice's advice, Todd accepted the prosecution's offer, entered a guilty plea, and the sentence was imposed. Has Alice violated any rules of professional responsibility? Discuss.
Great, thank you. Okay, this is going to be easier now. So we have So let's go to the issue of the charges. As an attorney, you have a duty of candor. Anyone know what this means? Record. Yeah, so these over here. Yay. With no false statements. Did she act honestly and truthfully with integrity to the court? Kinda. Okay, we can write those out. Argue that she didn't act honestly and truthfully because she allowed him to move forward with the case when he clearly was not comfortable with entering a guilty plea. From the facts, he kept repeatedly asserting his innocence. So letting your client move forward like that is a potential issue. And that goes to also the issue of, write this out really quick. I would organize it different. Let me do this over here. So there's scope of relationship and duty to communicate. All these kind of go together in this particular fact pattern. So what's the scope of the relationship? What's an attorney? How do you divide who makes what decisions in a relationship? Yes. Client makes all substantive decisions, and the procedural goes to attorney. Thank you. And in this particular matter, she needed to communicate, and she has to keep the client appraised on what's going on with the case, correct? Status. And this also ties into the competence issue too, because she has to render competent legal advice. So in this instance, did she let him make the substantive decision? What facts make you think that she did not make that substantive decision? Everyone's shaking their heads. Exactly. So there's a potential breach of this issue because she influenced him to make that decision. And part of this reason that she wanted to hastily make this decision, you could argue, was her lack of experience in the field, which she did not disclose in their initial discussion. Yeah? Well, yeah, that's a huge breach of duty because she was deferring to someone who wasn't an attorney. And she also, having a duty of competence and, to zealously represent your client, you also have a duty to listen and hear their side of the story, which she didn't do. And if he adamantly was maintaining that he was innocent, she had a duty to look into it further and not just discard what he was saying and to try and settle the case to make a third party happy. That goes back, it all ties in. It goes back to the duty of loyalty where she let this third party influence her decision. And it also was a breach of competence because she didn't act like a competent attorney would. She also didn't render competent advice, which falls under this, or pursue the matter diligently, because she didn't look into his claims. And she didn't communicate with him her lack of experience or expertise. She didn't communicate, as we just read, that at the subsequent court appearance, prosecutor offered to reduce the charge to simple felony possession and to agree to a period of probation on the condition that he undergoes inpatient treatment. She didn't disclose all of his options to him. He said, look, I'm innocent, don't I have any other choice? And she said that she thought it was his best chance. She didn't, try to negotiate. She didn't try to look at, what evidence they had. She just yielded to that pressure right away. which ties in back to this duty of candor, where she let her client enter into a relationship, or not a relationship, enter into a plea where he clearly wasn't comfortable and thought he was innocent. So it's an almost fraudulent act with the court. That and the fact that she let him submit to a plea where he clearly thought he was innocent, and she continued to pursue the case with clear lack of experience, wasn't conducting any research, didn't listen to the advice of the attorney that she associated with, and was operating under all these conflicts of interest with his mother. Yeah. You know, I've seen some answers where they'll pull out the diligent and the zealous representation to separate duties, and I've seen some where you can just kind of make it an umbrella under the broader category of competence. That's up to personal preference for you. I like to simplify things and make them in nice, readable chunks, but if it makes it easier for you to articulate your argument by pulling them out that way, then go ahead and do it. You'll get your point across either way. With this candor thing, this is a minor issue. The main issues are going to be this duty of loyalty, the competence, the communication, and fiduciary issues with the fee splitting. If I had read this, I wouldn't have pulled out the candor issue. My mind wouldn't have been there. It's kind of a stretch, but the sample answers do include that. Yeah. Uh-huh. Mm-hmm. As far as what's absolutely necessary and what's not. Yeah, I totally understand what you're asking. So what you need to kind of tell yourself in the back of your head when you read those sample answers is those are state release answers from the bar. Those are not absolutely perfect. They are best samples. And so there are going to be leaps and stretches in there. There are going to be some errors. They're going to have, maybe not perfect rule statements, but those are what the bar deemed as good examples of a passing answer. So you should look at those and kind of look at them side by side and see what they both have. And those are issues that you should probably need. Let me look at the sample answers for this one right now, actually. Okay, you need to not listen to that little doubt in your head because that's going to be counterproductive. Everybody has it. I have it. If I'm working on a case, there's always that little voice in the back of my head that, I'm not looking at enough issues. I can find some magical law that's going to just make the whole case a home run. But you just have to put your best foot forward and get as much as you can on there, and don't let that slow you down. Yeah, both answers put the candor issue, but they didn't spend a lot of time on it. 1 or 2 sentences. You would say, she owes a duty of candor and truthfulness to the court. There might be a breach of this duty because she let him enter into a plea knowing that he was maintaining his innocence and she wanted to pursue Betty's interest instead of his. that's all the time you need to spend on it. Yeah, it's something that wouldn't need more than 5 to 10 points. They're all trying to think. No, somebody asked me last class point breakdown. You did? Or are you going to ask that again? No. Yeah. As far as weight, this is going to be figuring out who the client is and the confidentiality with the mother. And then the competence issue, which these tie in. All they share a lot of the same facts. Okay, does anybody have any questions? Are you guys tired? There's a lot of PR for one day. Okay, well that's it. If you guys think of anything, ask me.